Lawyer John Deaton reacted to the news that the Securities and Exchange Commission would be appealing Judge Torres' decision in the Ripple case. He put himself in the middle of everything going on in this case and got Judge Torres' permission to do so. This put Deaton in the middle of everything. In addition to running for Senate, he already speaks for more than 75,000 people around the world who own XRP. While speaking for 75,000 token holders, Deaton fought against major mismanagement and overreach at the Securities and Exchange Commission. He did this for hundreds of hours and more than $75,000 of his own time. They also said that he had to come even though it cost him money and time because he had so many things he had to do for other people. There are people who work for his law company who help him. In his thanks, Deaton said that he appreciated how much time and effort Deaton put into fighting the SEC and making a big difference in the result of the case. During the court case, he said that statements from people who owned XRP were there because of him. Judge Torres talked about these papers, which is one of the most amazing things that has ever happened. Deaton was shocked when he saw the $75,000 number. It wasn't a very big ask since Judge Castell and Telegram had made it clear that the Gram token, like Bitcoin, was just a bunch of letters and numbers and not protection. On and on, Deaton said that the SEC only wanted to agree that XRP was not an asset. This wasn't a very hard request to make. After the decision was made that XRP was not a security, the Securities and Exchange Commission said they would not be reviewing. Even so, they made every good case for why XRP was a security throughout the whole case. The Securities and Exchange Commission said that they would not add that extra layer of security for all of that, even after the decision was made. By looking at how Attorney Deaton reacted to the bet, we can see how important his work is and how the case has changed in important ways. The Securities and Exchange Commission has decided to file an appeal of the Ripple court decision. He said that the Securities and Exchange Commission's choice to appeal the decision that XRP is not a security was due to the SEC's dishonest and false arguments during the probe. To sum up, this is what lawyer John Deaton said in response to the news that the Securities and Exchange Commission would be appealing. The decision in the Ripple case shows how important the work of Attorney Deaton has been and how far the case has come. People have said that the Securities and Exchange Commission is breaking the law by offering Bitcoin as a security. It is against the law to do this. The Securities and Exchange Commission says that a man from Texas and his business are guilty of stealing money from investors in a Bitcoin Ponzi scam. People buy things or use services online with virtual currencies that can be sold for real currencies like the US dollar on online exchanges. This was an important event in the world of cryptocurrencies. According to claims made by the Securities and Exchange Commission, Trendon Shavers set up and ran Bitcoin Savings and Trusts, PCC, the Sudan Empire to market and sell Bitcoin-based products to customers over the internet. Based on how much Bitcoin cost on average in 2011 and 2012, Shavers was able to get at least 700,000 Bitcoin through purchases, which is more than $4.5 million. 700,000 Bitcoin were worth more than $60 million when the investments were being bought and sold. As per the Securities and Exchange Commission, Shavers promised investors that they would get up to 7% weekly interest based on augmented reality arbitrage behavior in the Bitcoin market. People who wanted to buy Bitcoin quickly or in large amounts were reportedly sold Bitcoin as part of this activity. Shavers used Bitcoin from new investors to pay claimed interest and cover investor withdrawals on BTC investments that were still outstanding. It was a farce and Ponzi scheme, not what it seemed like. Shavers used Bitcoin to pay investors who took money out of blockchain deals that were still open. Having said that, this nonsense in the Ripple case did not cause Bitcoin to be taken off of platforms, which wasn't an attempt at fraud and didn't even say there was fraud. The Securities and Exchange Commission was much more hostile and wrong in how they acted. The SEC was much stricter with the Ripple case, which wasn't even about theft of any kind. This was a clear attack on anything that had to do with coins. The case of Orange Groves is another example of how silly the method is. Steps that the Securities and Exchange Commission took. In this case, the SEC said that the oranges grown in Hawaii were not listed securities, even if someone bought them at a grocery store 1,000 miles away and didn't know anything about the company. That the Securities and Exchange Commission could use to back up its ridiculous claim would not be possible at all. A judge who has been a Democrat for a long time and was picked by Barack Obama also agreed with the amicus brief and other people and said that XRP is not a security. In the end, the way the SEC handled the Ripple case and other problems in the cryptocurrency business was a huge step forward for cryptocurrencies. The SEC's harsh and unnecessary handling of the Ripple case shows how silly the cryptocurrency business is. It also serves as a lesson of how important it is to think about the pros and cons of using assets as securities and selling them. In this talk, The speaker talks about the debate that has surrounded the SEC's choice to label cryptocurrencies as securities. Judge Torres made this choice. Barack Obama chose him to be a judge. People in the Biden government are generally against cryptocurrencies, which has led to fears that this move could hurt the cryptocurrency business. On the other hand, the speaker agrees that the rule of law is usually followed to some extent and that justice is usually done through the court system. The speaker brings up something Judge Sarah Netburn said, who said that the Securities and Exchange Commission's legal stances are not based on a genuine commitment to the law, but on how the market thinks the SEC will regulate Bitcoin. His point pretty much said that the Securities and Exchange Commission is picking its lawsuit positions not because it really wants to follow the law, but because it wants to further its own goals in the SEC Ripple case. A lot of people think this quote is one of the most memorable. Also, Neer said something about the Ripple case that comes from a headline that doesn't support the SEC's decision to keep Heineman's paper secret. This quote was written on July 13, 2022, which is exactly 1 year before it was announced that XRP Victoria was not a real security. The Securities and Exchange Commission tried to get the judge to keep Heineman's paper secret, but the judge said no. The judge said that the speech doesn't add to what the market knows about whether or how the SEC will control Bitcoin. In connection with the Depbox case earlier this year, a federal judge put a ban on lawyers working for the Securities and Exchange Commission. The Securities and Exchange Commission closed its office in June because the Depbox coin lawsuit did not succeed. This showed that many employees had left. At the end, the speaker says that the SEC lawyers said sorry for suggesting tokens as securities in a different case. According to reports, this is because the SEC is against cryptocurrencies and will now waste more tax money. In September, the Securities and Exchange Commission changed its mind about long-standing policy of classifying cryptocurrencies as securities. It said it would use more careful language in the future. In a complaint made in 2023, the Securities and Exchange Commission accused the cryptocurrency exchange Binance of promoting and selling securities that had not been registered. This led to the retraction. One of the 10 crypto assets that the Securities and Exchange Commission has recognized as securities is Solana Cardano. Another 2 are Polygon. The Securities and Exchange Commission says it's sorry if its call of these tokens as crypto asset securities and plans caused any misunderstanding. To change their words to be safer in the future. In the end, the speaker stresses how important the rule of law is and how it fits into the legal system. There may be times when people are treated unfairly, but the rule of law is usually followed to make sure that the Bitcoin business runs smoothly and fairly.